Christina Costantino appearing on behalf of Haley Gregg.
Your name?
Haley Gregg.
Judge, this is the date and time set for PCC. I was just appointed quite literally about 10 minutes ago. So given that, I would be asking for an adjournment of the PCC.
Is this the only thing holding her?
No, you're
All right.
Judge, it was my understanding that her only other hold was a Melvindale misdemeanor warrant, and Melvindale has indicated that they would not pick up on that warrant.
Well, I'm just looking, do you want 12 days out or you want 1 week? Because she's in custody. So I can do the 1st or the 6th.
Fortunately, Judge, I'm in trial next Thursday, so I can't do next.
Can't do the 1st, so I'll set it for the 6th for PCC. It's a Tuesday.
I have a look at the 2,000 cash of surety bond on an RNO A and B case.
I thought you had you said you had
That's what he said. No, there's not.
After failure to
That's what I'm
appear.
saying. I don't understand.
All right, I'm just trying to get her, I'm just trying to give her the quickest date I can.
Understood, Judge.
So if you're not available the 1st, I'll do the 6th.
That would be great, Judge. Thank you.
May 6th, 2025. That's at 9 a.m. All right, for a probable cause. All right,
Thank you, Judge. I
thank you.
would also like to address bond. I know we've
She would.
touched on it a bit. It's my understanding her bond in this matter is $5,000 with a 10% bond. It's my understanding of the circuit court matter that I think that people were mentioning a second ago. My client tells me she received a personal bond on that file at her last court date. She is 34 years old. She does have employment lined up should she be released. She would be working at a medicinal cannabis retail store. She would.
Okay. Now go ahead. It's like,
She does.
like she has a job at a liquor store. Go ahead. No, I'm kidding. Go ahead.
Very important jobs. It's a very important sector of our economy. She does have housing lined up as well.
Wow.
She would
You're
be.
vouching for that.
She would be.
Yeah, Tina?
She would be. She would be able to reside in the city of Ypsilanti with a friend. She also is on the housing list through Avalon Housing. She would be working with CMH. She, previous to her incarceration, was working with CMH and attended therapy at least 2 times a month. It's my understanding that the other holds out of Wayne, as mentioned, they would not pick up on. We did ask the court to consider a personal bond. If the court is willing to do so, we would also ask if the court would consider release to treatment. She has indicated that she does think treatment would be appropriate for her at this time.
Kind of treatment.
Substance abuse treatment.
Ah, at the cannabis store. No, I'm kidding. Go ahead.
Your Honor, at this time, we believe that her bond is appropriate. She does have multiple other matters pending. We would point out that the date of offense in this case is the day after she was released on another case. I don't know if you remember Ms. Gregg from last time she was here. But Your Honor, given that she picked up this case.
Because she had to drive, because she had to get away from here after she was released. So she just grabbed a car. Whose car did she grab? Allegedly.
Allegedly, Judge.
Allegedly, did she? It was a police car.
No, what?
Okay, never mind. My bad.
No.
She just took a car because she had to go. Allegedly.
Allegedly, Judge. Perhaps a great middle ground for her. She's indicated a willingness and a desire to obtain treatment. Certainly, I think with treatment there, the risk of failure to appear is significantly diminished.
If you prepare an order, I'll release her on a PR to treatment.
Thank you very much, Judge.
Your Honor, could there be a tether for to keep her in inpatient treatment at that place?
Well, I'm not really.
I don't know that she's going to need a tether. I mean, if she goes into treatment, no, I'm not going to do a tether on her. I'll just indicate that she can be released to treatment on a PR.
Thank you, Judge.
At this point, however, her bond will continue.
Thank you.
Okay.
And good afternoon or good morning, Judge. Amir Immaculate on behalf of Mr. Burkett.
Good afternoon.
Morning,
Good afternoon. What's your name?
Jason Matthew Burkett.
All right. Okay, what are we doing on this case?
Your Honor, I'm asking to be withdraw as counsel for Mr. Burkett. I haven't spoken to him. He was capious last time we were there, and we were never retained. So I'd ask the court
You
to
were-
allow me to.
You were never retained. Say again?
He was supposed to retain us, or a family member, or his employer was supposed to retain us, but nobody ever did.
Wow. Okay.
And the last time we were in court, he capious, so I haven't had any contact with him since then.
Okay, so, well, we got a problem then. Constantino's not still here, is she? Oh, is she coming back?
She was in the hall.
She was in the hall?
She was in this room out here.
All right, so we may be able to, because the PD initially withdrew on his case. Part of that withdrawal appointed Constantino, but then I think you were gonna step in. So that's kind of what. Well, no, hold on.
I had it, Your Honor, as the PD got out because Mr. Mockley got hired, but I'm not sure. That could be incorrect.
No, no, because I have the withdrawal, the motion to withdraw that I signed. The order of withdrawal, and then Ms. Constantino was appointed to represent you.
She left, she's not here.
She's not here. All right. So sir, do you have any objection to Mr. Macklin withdrawing?
I have no idea what's going on, sir. I thought, no, if he's withdrawing, then I
Okay, so here's what I'm gonna do. I don't think I need a new order, but what I'm gonna indicate is that
don't know how things got confused, Your Honor. I'm sorry.
I'm gonna permit him to withdraw.
Thank you, Your Honor.
And then I'm gonna indicate that the PD previously withdrew.
Due to a conflict, Your Honor.
I know. Why are you slipping in? Why are you slipping? Sit down. Well, I'm gonna need it. Yes, I'm gonna need an order from you, counsel, permitting withdrawal. The court isn't appointing, but the court, I'm gonna have this case go back to Ms. Constantino. And we'll do it that way.
I'll email the court within a few minutes.
Alrighty, thank you, sir.
Sure.
All right, and
Better-
here's what I'm gonna do. She's coming back. What? She here next week? He wasn't available on the first. So here's what I'm gonna do, sir. I'm gonna set the next available date so that counsel can get to you, talk to you, and see what we can do.
Is there anything, I wanted to ask, is there any way I could be released on the PR bond? Like I said, this got confused. I thought he said we was getting dismissed and we got crossed up. I would have never missed. I talked to Officer Stanky actually on
All right,
Friday.
let me do this. Hold on.
Okay. 'Cause I'm
Probable
looking at
cause
the job tomorrow.
conference, May 6, 2025, 9 AM. Do people have a position on his bond?
Just one moment, Your Honor, just to get into the warrant request.
And can I say one more thing? I'm sorry, sir. I was trying to get in with the
So, sir, why didn't you show up the last time?
the last time, like you said, we were confused. I thought he said he was gonna call me back and tell me the court date. I never got received a court date. I would have reported. And like I said, I spoke.
How'd you come back into custody?
Well, I talked to Officer Stinky on Friday And he told me, he said it was a forgery charge I had out for me. I see him down by the Delana Center, and then Delana said that I was threatening to commit suicide, so they called the police on me, and then they ended up picking me up that way. But, I got, well, kind of still have like an interview I could get tomorrow. That's what I'm wondering if I could, any way I can make it out to make that. I really need this job.
I'll leave it in the court's discretion. I see one hold in your 1 weeks for traffic for driving suspended, so I don't know if we can get him on that or not. I really
Doubt
don't
it.
know.
Yeah.
But, I don't see a big history of fires with the landscape at one time.
Yes, like I said, it was a complete mix up.
I'm gonna set your bond at a $5,000 personal recognizance. All the conditions that we previously set will apply.
Okay, thank you very much.
Setting your new date for May 6, 2025 at 9 a.m. here.
Well, sir,
If you don't show up, you won't see the light of day.
I'll probably be early.
You hear me?
I'll be early, sir. I appreciate
Thank
it.
you.
Thank you.
And Ms. Constantino will be getting in touch with you.
Thank you.
Court does call the case people first.
I'm sorry, my phone is broken on Sunday. Is there any way I can get like a business card for her? So I can call her tomorrow? I mean, I might have a new phone tomorrow. I just wanted to make sure.
Judge, I have her number. I can write it down.
Thank you.
As we wrap up this courtroom session, let's break down everything that unfolded. Because this hearing had layers of legal tension, unexpected turns, and some surprisingly human moments that reveal how complicated these cases can become. We began with attorney Constantino stepping in at the very last minute, literally 10 minutes before the hearing, and immediately requesting an adjournment of the PCC. That alone sets the tone. When defense counsel is appointed moments before a proceeding, the court must decide between efficiency and fairness. The judge, recognizing the defendant is in custody, pushes for the earliest possible date. Counsel, however, cannot appear on the 1st due to trial obligations. So the judge sets it for May 6, 2025, balancing the defendant's right to a timely hearing against counsel's availability. This scene is a perfect example of how courts juggle calendar logistics versus due process needs. Next comes the bond argument. And this is where things get intense. Defense paints a picture of stability, employment lined up, housing lined up, engagement with counseling, a willingness to enter treatment, but the prosecutor pushes back, focusing on patterns, prior cases, and flight risk, highlighting a failure to appear and the fact she allegedly took a vehicle because she had to get away after her release. The humorous misunderstanding about a police car briefly diffuses tension, but the underlying concern is serious. Is this defendant likely to run again? The defense counters with an interesting strategic angle treatment as a middle ground. This is common in modern courts, balancing accountability with rehabilitation. And the judge agrees to release to treatment if an order is prepared. But importantly, he keeps the bond in place for now, showing a cautious but open approach. Then the second case begins, and suddenly we have a full-blown attorney assignment mess. Attorney Land asked to withdraw, stating the defendant was supposed to retain him but never did. Meanwhile, the public defender previously withdrew, and Constantino had apparently been appointed, but was now absent from the room. This is the kind of behind-the-scenes legal chaos viewers usually never witness. Multiple attorneys entering and exiting a case, communication breakdowns, and a defendant caught in the confusion. The judge sorts it out. Land is allowed to withdraw the case, is reassigned back to Constantino. New date is set so counsel can properly meet with the defendant, but before the hearing ends, the defendant makes a personal plea, a moment that humanizes the courtroom. He explains the confusion about court dates, how he believed his attorney would call him, how he was arrested after concerns about his mental state, and how badly he needs a job interview the next day. Whether you believe him or not, this moment shows how people often walk into court with layers of fear, miscommunication, and personal hardship that don't always fit cleanly into legal rules. The judge listens, evaluates the situation, and despite a failure to appear, sets a $5,000 personal recognizance bond. That's significant. It means the judge believes the confusion may have been genuine and that the defendant isn't an immediate risk if released. But the warning is crystal clear. If you don't show up, you won't see the light of day. A line that shows both firmness and finality. Finally, the defendant asks for his attorney's contact number because his phone is broken. One last reminder that the smallest real-world issues can have massive consequences in the justice system. Missing one phone call or losing one device can snowball into warrants, arrests, missed hearings, and life-altering outcomes. So what do you think? Was the judge fair in granting a PR bond here? Should treatment have been granted earlier in the first case? Do you think miscommunication is a valid reason for missing court, or is it still on the defendant to keep track? Drop your thoughts in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.